Good evening, friends. The convener of the Tamil Nadu Senior Advocates Forum, Mr. Somayaji, and the co-convener, Mr. Parthasarathi, will lead Honorable Mr. Justice Lalit and Honorable Mr. Justice Krishna Kumar to the dais. On the 26th of November 1949, we, the people of India, adopted, enacted, and gave to ourselves the Constitution, which outlined a unique structure of government. We are meeting today to celebrate the historic 75th Constitution Day. We begin the auspicious occasion with Tamil Thai Vaazhthu to be rendered by Ms. Jayalakshmi, Advocate.
நீராறும் கடலுடுத்த நிலமடந்தை கெழிலொழுகும் சீராறும் வதனமென திகழ்வரத கண்டமிதில் தெக்கணமும் அதிசிறந்த திராவிடனல் திருநாடும் கதிரு பிறை நுதலும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீரிழமை திறன் வியந்து செயல் மறந்து வாழ்த்துதுமே வாழ்த்துதுமே வாழ்த்துதுமே.
Thank you. I request the Chief Guest, Honorable Mr. Justice Lalit, and the president of this evening's function, Honorable Mr. Justice Krishna Kumar, to light the Kuttuvilakku. The preamble to the Constitution is the reflection of the values that embody the Constitution. Mr. Ashwin Surender will now read out the preamble.
We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure among all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this, the 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution.
Don't you get goosebumps every time you hear this? Thank you, Ashwin. Now, Mr. Om Prakash, the Secretary of the Tamil Nadu Senior Advocates Forum, will deliver the welcome address.
Good evening, everybody. It's a wonderful occasion of meeting all of you in celebrating the 75th Constitution Day. We are here to have it as an inaugural function, and we have the privilege of the presence of Justice U. Lalit to grace this occasion and enlighten us on various aspects. The Tamil Nadu Senior Advocates Forum had been striving with endeavors to bridge the gap between the bar and bench, to stand as a bridge between the bar and the legal field, to stand as a bridge between the students and the lawyers. In this endeavor, we had committed ourselves to various activities, and one such being the function which we are holding today. It is in fact a privilege to stand before you in welcoming all the guests for the day. We have the honor and privilege to welcome each one of you to this momentous occasion as we come through to celebrate the 75th Constitution Day of India. When we had conceived this as a spark, when Mr. N.L. Raja had called upon the members to think about some event for the 75th Constitution Day, we were looking at only inviting Justice Lalit. A small background to that would be that last year we had reached out to Justice Lalit to have a Law Day celebration at Dr. Ambedkar Law University. Due to his prior commitments, he couldn't commit to us for an event at that time. And this year, sometime around August, September, we again reached out to Justice Lalit, asking his convenience to have a session at Chennai. And Justice Lalit had said that he had too many commitments running around the country, and more particularly he was referring to his assignment at West Bengal as part of the Supreme Court order, and he said, till November 15th, I am somehow tied up here and there, but I will keep it in mind and let you know as and when an occasion comes. Then we had again informed him that we may have this program as 75th Constitution Day, starting from November 26th, and Justice Lalit immediately informed that 15th I am there at Chennai, and you can schedule a program for that. So with that, we started in midst of all his hectic schedules. Justice had made it to us. Justice Lalit's tenure has been marked by his unwavering commitment to justice and fairness. His vast experience both as an advocate and as a judge has shaped some of the most important legal precedents in our country. His presence here today adds immense value to the celebration of our Constitution, and we look forward to hearing his reflections on the constitutional guarantees, the path in 75 years. As we were informing our members that we are going to have a function where Justice Lalit is going to deliver his address, I had many from the senior-most of the bar to the junior-most having informed me that we had the occasion of having some interaction or other with Justice Lalit, and most of the time it was his tenure as the senior advocate in Supreme Court. And his tenure as on the bench had been a tremendous thing, though it was a very short period. So it is a great privilege to have Justice Lalit today amongst us. I extend a very, very heart welcome to Honorable Justice U.U. Lalit for this occasion to this Madras High Court and deliver his address. When we had so many functions for Tamil Nadu Senior Advocates Forum or some initiatives, we had a very big pillar of strength in the form of Justice D. Krishna Kumar. Whatever we have travelled as on date, as to small initiatives which we have done in the last 2 years, there had been always a role which was played by Justice D. Krishna Kumar. In fact, he had been coming up with various suggestions, and I take this occasion, in fact, to profoundly thank him that he had agreed to provide a launch for senior advocates in the principal bench as well as the Madurai bench, which the building committee consisting of Justice R. Subramaniam, Justice Suresh Kumar had approved, and we are in the process of having a senior advocates launch at Chennai as well as at Madurai. So take this occasion to thank Justice Krishna Kumar for this wonderful initiative of carrying us forward. And at all times when we had reached, he had been very, very happy to be part of our programs. So on behalf of all of you, I extend a very, very hearty welcome to Honorable Justice D. Krishna Kumar. And we have many judges who have come here and are knowing.
Will be honored by the co-convener, Mr. Parthasarathi. We have assembled today to celebrate the anniversary of a momentous event, the anniversary of adoption of our Constitution, the day on which our founding fathers subscribed to this document by signing the same and thereby unfolding the philosophy, social, economic and political for the governance of free India, proclaimed the Honorable Mr. Justice S.H. Kapadia, former Chief Justice of India, on the occasion of the first celebration of Law Day. I request Honorable Mr. Justice Krishna Kumar, who has been settling law on constitutional issues, both as a lawyer and as a judge, to deliver the presidential address. Mr. Krishna.
Honorable Justice U. Lalit, former Chief Justice of India, esteemed brother judges of this Chartered High Court, Justice Subramaniam, Justice Kutus, Justice Seshai, Justice Sundara Mohan, and former judges of this court, Mr. A.L. Soumyaji, convener, Tamil Nadu Senior Advocate Forum, Mr. Parthasarathi, co-convener, Tamil Nadu Senior Advocate Forum, Om Prakash, Secretary, Tamil Nadu Senior Advocate Forum, Mr. Bhaskar, President of Bar Association, Thiruvengadam Secretary, Madras Bar Association, Revadi, President, Women Lawyer Association, respected members of the Tamil Nadu Senior Advocates Forum, and other office bearers of the other associations, distinguished guests on the dais, and ladies and gentlemen. Good evening to all. It is my esteemed privilege to welcome you all this momentous occasion, the 75th Constitution Day celebrated by the Tamil Nadu Senior Advocates Forum. Today we gather to commemorate the adoption of our Constitution, the foundation of our democratic nation. We are deeply honored to have with us today the former Chief Justice of India, Shri U. Lalit, who is graciously delivered a special address on constitutional guarantees, path in 75 years. Honorable Justice Lalit tenure as the 49th Chief Justice of India, an indelible mark on our nation's judicial landscape. Under his lordship's stewardship, the Supreme Court made significant strides in upholding the principles of justice, equality, and individual rights. I would like to mention some of the landmark judgments delivered by Honorable Justice Lalit. Kashinath Mahajan vs. State of Maharashtra, AR 2018 Supreme Court 1498, Justice Lalit and A.K. Goyal introduced safeguards under the SC/ST Act requiring a preliminary police inquiry, supervisory approval before arrest, and guidelines for anticipatory bail to prevent misuse of the Act. Shayara Banu vs. Union of India, Tribute Talak case, reported AR 2017 Supreme Court, page 4609. Justice Dalit, part of the Constitution bench, ruled that practice of instant tribute talak was unconstitutional, violating the right to equality under Article 14 of the Constitution of India. Shri Padmanabh Swami Temple case, reported AR Online 2020 Supreme Court, page 639, upheld the Travancore royal family's right to manage the temple, affirming that temple management rights follows hereditary succession. His Lordship's commitment to judicial reform and accessibility has inspired a new generation of legal practitioners. Honorable Justice U. Lalit, remarkable career spanning over 4 decades, is a testament to his unwavering dedication to the legal fraternity. His expertise, wisdom, and fairness have earned him the reverence of his peers and the gratitude of our nation. We therefore could not have asked for a better Chief Justice for this function. As we are celebrating 75th anniversary of our Constitution, we reflect on its transformative journey. From the visionary framers to the tireless efforts of jurists, our constitutions evolved, adapting to the changing needs of our society. Today, we reaffirm our commitment to the Constitutional Preamble, justice, liberty, equality, and fraternity. We acknowledge the progress made and recognize the challenges ahead. Today, we are not just honoring the past, we are shaping the future. We must ask ourselves, what kind of India do we envision? How will we ensure justice for all? How will we safeguard our freedom? As we stand here today, celebrating 75th anniversary of our Constitution, we find ourselves not only commemorating the past, but also renewing our dedication to the foundational principles that guide us as a nation. Our Constitution, crafted with vision and wisdom by the framers, is more than mere legal document. It is a living testament to our collective aspiration, values, and rights. Today we reaffirm our commitment to the ideals it enshrines: justice, liberty, equality, and fraternity, pledging anew to make these ideals tangible for every Indian. The judiciary plays a crucial role in this pursuit. As guardians of the Constitution, our courts and judges bear a profound responsibility to uphold and to protect the individual and constitutional rights and to foster a society rooted in social justice. The judicial system, often the final bastion for citizens seeking redress, must remain vigilant and impartial, standing as a pillar of hope for those who may otherwise feel marginalized or unheard. It is the duty of all legal practitioners and institutions to work towards a justice system that is accessible, fair and reflective of the highest ethical standards. Moving forward, let us draw inspiration from the Constitution Preamble, which embodies our nation's core values. The call of justice is not limited to legal rights alone. It encompasses social, economic and political justice, urging us to dismantle barriers that prevent citizens from fully participating in the democratic process. The promise of liberty requires that we not only protect individual freedom but also create an environment where all Indians can exercise their freedom without fear or discrimination. Equality too remains a paramount goal. While we have made substantial progress in building a more suitable, equitable society, much work remains. Economic and social disparities still challenge us, and it is our collective responsibility to bridge these divides by ensuring that every citizen has access to education, health care, and economic opportunities. We make strides toward the true equality. Fraternity, the final principle in our preamble, reminds us that unity and harmony are essential for national progress. As a diverse country, we must celebrate our differences while reorganizing our shared identity. This fraternity binds us together, fostering mutual respect and cooperation as we work towards a common future. As we celebrate this milestone, let us also reflect on the crucial role of education. Education is not only means to personal empowerment, it is a bedrock of a democratic society. An informed and educated citizen is essential for upholding democratic values and fostering a culture of active participation in public life. As we look to the future, we must prioritize educational initiatives that encourage critical thinking, inclusivity and understanding of constitutional rights and duties. In facing the challenges ahead, let us embrace the transformative potential of collective action. Whether it is combating poverty, addressing environmental issues, or promoting social harmony, it is only through unified effort that we can build a resilient and prosperous India. Let us pledge to make our country one where every citizen can live with dignity, where every voice is valued, and where justice is accessible and swift. Our Constitution remains a beacon of hope, a roadmap toward a brighter, more inclusive future. As we stand here today, let us honor the spirit of our Constitution, not only in words but in action. Let us work together to build a nation that is just, equal, and free, and uphold the principles that have shaped our past and continue to guide our journey forward. Before I conclude my speech, I would like to express my appreciation once again to the Tamil Nadu Senior Advocates Forum for organizing this significant event. Your dedication to the legal community and the Constitution is truly commendable. Thank you, sir, for giving this opportunity. Thank you very much.
Thank you, Judge, for explaining the rights and duties of every citizen as enjoined by the Constitution. The majestic phrases of the Constitution fix limits and perpetuate historic ideals, but their genius also lies in leaving for the future questions upon which they could not agree and other questions that they could not possibly foresee. The judges of this country have to decide the unanswered questions as they arise. The judges are required, on the one hand, to preserve their authority by building a body of law, linking each new decision to the sacred document, and on the other, to meet new realities and changing needs and aspirations of later times. The Honorable Mr. Justice U.U. Lalit, former Chief Justice of India, did this with aplomb. Sir, we await your special address on constitutional guarantees, the path in 75 years. The Honorable Mr. Justice Lalit.
Mr. Justice D. Krishna Kumar, President for the function today. Honorable Somayaji, Parthasarthi, and Om Prakash, all senior counsel of this court, and who are behind this organization, all the past and present judges of this High Court, all the learned senior counsel, members of the bar, students who are present in some number here, ladies and gentlemen. I'm not a great speaker. I lost the habit of speaking in court about 10 years back. Since then, I have only been listening to arguments, so therefore, pardon me if I'm not so fluent in placing my matter before you. What was so touching about the initial address was the fact that when the preamble was recited, it was rightly said that it still sends goosebumps on everybody's, the very presence of that, something so electrifying. I had the occasion to see the picture copy of the original Constitution, which has the signatures of some of the leading stalwarts who were the members of the Constitution. And then one wonders what kind of collective wisdom, statesmanship, and foresightedness was there in that chamber which gave us this Constitution. Many political scientists around that time thought that this perhaps would be a very short-lived dream. There are more than 500 Indian states. There are diverse cultures, different languages, different heritages, different backgrounds that we come from. Perhaps I think this country may not be able to hold everything together. But leave aside that doubt which was lingering in the minds of some of them. 75 years have shown us that our borders are secure, number one. Internally, the democratic apparatus is thriving to such an extent that now we have, under the constitutional status, even village panchayats, municipal councils have been also thought of a democratic kind of setups at every level. There have been 4 areas which were added to this union after the Constitution came into force. Goa, Daman and Diu, Pondicherry, Mahe, Yanam, Karaikal, and before that Dadra and Nagar Haveli, and finally Sikkim. We haven't lost any territory in law. There may be certain kind of encroachment somewhere, but as a matter of law, we haven't lost any territory except for one amendment where certain territories were exchanged with Bangladesh. So that's the beauty of all this setup that we have seen for the last 75 years. What is it that has been binding us as a nation together, as a political apparatus structure together? It is this Constitution. The Constitution which has given us certain kind of guarantees so far as a citizen is concerned at that level, and there are guarantees also beyond the level of the participation of a citizen, and this is something which this Constitution has given us. It has suffered some amendments, almost 106 or 7 amendments up till now. But that's a different story, and that's also one of the parts that we must also consider. That we are the only nation in the entire world which has subscribed to this theory of basic structure. That is to say, even so far as the Parliament's amending power is concerned, we have put certain restrictions on that. And that's the beauty of our democracy, that's the beauty of our constitution, that's the beauty of the constitution as has been interpreted by the courts. Very well, many political thinkers and great lawyers would say that if it comes to constitutional guarantees, where do we find the basic hub of the matter? Which are those critical areas without which perhaps I think this constitution would be a lame exercise? And political thinkers are almost unanimous in saying that if there be 3 articles in the part 3 of the Constitution, that is 14, 19 and 21, this is the tripod on which the entire edifice of the Constitution is based. But at the same time, soon after the Constitution was adopted, Ambedkar had said that if at all there is one article in this Constitution which is of greatest significance, it is Article 32. And 32, as all we lawyers know, is part of your guarantee itself, Part 3. So therefore, look at the beautiful part of it. We have always seen as legal scholars that very well Marbury versus Madison gave us what is called judicial review. The new frontiers got sort of established as a result of that. Well, forget Marbury versus Madison, we have given it a constitutional status in Article 13. That every action has to be in conformity with Part 3 rights, any legislative enactment or even an executive action. And in order to see that perhaps there has to be a window through which the grievance can be ventilated, our Constitution gave that window also a constitutional status, a fundamental right in the form of Article 32. So therefore, to my mind, if one goes by this logic that 14, 19, 21, add to it 32, and you have 4 wheels of this chariot, which is so beautifully driven for last 75 years and has taken us towards the egalitarian society that we have always aspired for. Economic and statistical analysis will always show that the day when we earned our independence, 1947, and today, perhaps economically, we are far, far superior and in a greater position. How has that been achieved? When we got independence, we had barely just about, I think, some statistics said about 70 universities in the country. Today, there are more than 5,000 universities in the country. So higher education is something which has been guaranteed to almost every citizen. Primary education, which was part of Part 4, is now Part 3 right for every citizen. These are some of the developments, some of the frontiers which have been crossed by us in last 75 years. So therefore, let's take a brief resume of this. As I said, 14, 19, 21 and 32, and I said in passing that we have this evolution of beautiful principle called basic structure. So therefore, let's start with that, Article 13 and basic structure doctrine. I had the occasion to discuss this matter with many people, and if you recollect how the things actually started developing, first submission in Sankari Prasad way back in 1951, Patanjali Sastri presiding over a bench of 5 judges, that even a constitutional amendment must be taken to be quote unquote law within the meaning of Article 13. That was the submission which got rejected. And the court said that constitutional amendment process is different from lawmaking process, and therefore the limitations or the conditions prescribed by Article 13 would not get attracted at all. So Sankari Prasad rejected the submission, First Amendment challenge was negated. Then comes the next line, which is Sajjan Singh, Justice Gajendra Gadkar presiding. In that matter, 3 judges adopted the reasoning in Sankari Prasad, but 2 judges struck not a discordant note, but at least a caveat was entered by them, saying that perhaps this entire branch of law needs a relook. Justice Hidayatullah said that, sorry, as now advised, it needs a fuller discussion, and so therefore I am not inclined to accept Sankari Prasad as the law at this stage. Justice Mudolkar, the 5th judge, went 2 stages further. And he, for the first time, said that there has to be some basic spirit of the Constitution which goes beyond the purview of amending process. And that's the logic of basic structure which got ingrained for the first time way back in 64 October. And that's how we then traveled. Then came another case, which was Golaknath, 11 judges. And Golaknath for the first time accepted that submission which was rejected in Sankari Prasad and Sajjan Singh, that yes, Article 13, for the purposes of Article 13, even a constitutional amendment shall be considered to be law. 6:5, the court held that yes, every amendment must be satisfying Article 13. Therefore, logically, even the amendment must actually be subservient to your fundamental rights. And that opened something like a Pandora's box for the community of lawyers, the judges, the entire fraternity to be sort of wrecking their brains and say that whether is this correct or not. Within 6 years, the matter was decided by another full court, this time 13 judges in Keshwanand Bharati, and that's that logic which has given us is that yes, we don't go to the extreme which Golaknath has gone, that is every amendment must subserve 13. We also don't go to the other extreme like a pendulum, that everything is beyond the purview of Article 13. We will strike something in between. And what was that? That even an amendment must actually satisfy certain basic ideas of the Constitution, the basic spirit of the Constitution. And this is one guarantee which was given by a judge-made law in 1973, which for last 51 years has been the ethos of this country. Since then, starting from Keshwanand Bharati in 1973, Indira Nehru Gandhi in 76, Menon Mills in 1980, Samba Murthy in 1986, 1992 Kyoto Holohan, 1997 L. Chandra Kumar, and then NJAC, the last one in 2015. We have had 7 instances where constitutional amendments have been struck down by the Supreme Court. And that's the logic to which level we come. That we say that even the amending remaining power of the parliament, which is sui generis, must be subject to certain limitations, and those limitations themselves now become our guarantees. All these 7 cases have actually struck down the amendments on what? Rule of law, independence of judiciary, basically an amalgam of these 2 ideas. There had been 2 instances where we went very, very close, when there was a dissenting note which said that the amendment must be struck down, which was in R.C. Podial, where Justice L.M. Sharma as Chief Justice was the lone dissenting note, and he said that in Sikkim, where a legislative assembly seat is given on religious ground, is anathema to the Constitution, is something against the basic principles of the Constitution. But the majority accepted it, so therefore the amendment was sustained. It did not perish. And the last was this 103rd Amendment, EWS quota, where again 3 judges of the court accepted the amendment to be true and correct, while a minority view said that the amendment must perish. So we have these 7 plus 2 cases where we have very nearly come to that level. And that's the beauty of our system. That's the beauty of what I call some of the guarantees given to every citizen. Now we come to the actual guarantees which are part of part 3. You know, the very first case which was argued in Supreme Court on constitutional issues was by a gentleman who came from this court, M.K. Nambiar. And the case was Gopalan, 1950, where preventive detention law was challenged, among other things, including the order of detention which was passed against Gopalan. There's a very beautiful write-up by somebody, and he said that in 1950, when Supreme Court opened its doors, 2 Nambiars entered Supreme Court, one through the registry, which was A.K. Gopalan, and the other Nambiar as a counsel, which was M.K. Nambiar. And they have contributed to the development of jurisprudence in Supreme Court to such a great extent that the Supreme Court and the judicial organ will always be indebted to them. Why? Nambiar lost the case in Gopalan. But what Nambiar advocated for the first time in 1950 is saying, number 1, that constitutional guarantees given by every fundamental right article in that chapter is not a mutually exclusive compartment. A challenge can be raised on a combined reading of some of the articles. It need not be in one slot, whether you come under 14, whether you come under 19, 21 or 22. That argument was rejected by Chief Justice Kania. And according to him, if it is law of preventive detention, then we must look towards the proximate article, which is Article 22. And the rest of the articles we need not even look at. This theory, of course, prevailed till R.C. Cooper. But that theory obtained, and R.C. Cooper for the first time accepted what Nambiar had advocated. That a person who is preventively detained can also bring forth his case, put it under 14, put it under 19, some of the articles, and say that the effect of this detention is that my right to travel across the length and breadth of the country gets completely curtailed. So therefore the effect theory or that matter can be projected from not just confined to one compartment, but as a collective idea was accepted in R.C. Cooper. The second submission which Nambiar advanced, that when you say procedure established by law under Article 21, we must read due process principle, which is normally accepted in American jurisprudence. So that law must be fair, that law must be just, that law must be equitable, rational. Again, rejected in first Gopalan, but then accepted in Maneka Gandhi. And that's when you realize that what kind of foresightedness that man had when he projected these kind of, arguments for the first time in Supreme Court. Very well, that's where we started. So now let's go on to some of these limbs, which are 14, 19, and 21. Since we are on 21, which is the fairness doctrine, one of the classic expounding of the principle came in Maneka Gandhi. That when you say right to life, liberty, does that mean animal existence? Does that mean sheer physical presence on this earth? Or does it mean something greater than that? Does it mean that the individual, as an individual, must be given every chance to attain the highest potential that he can, highest levels that his potential can actually reach? And that is to say that create an atmosphere for an individual where he can, without there being any bounds, without there being any kind of restrictions, can develop his potential as a human being to the fullest. And that principle was given to us in Maneka Gandhi. I always say that, there have been many scientists, many persons who must have seen apples falling from the tree. But there was only one person, Isaac Newton, who could find the principle behind that. There had been many persons who may have been denied passports, but there was one man who could see a principle behind that and could expand that principle and give it to us on a platter, what is called the expanded meaning of right to life. So much so that very same principle, Article 21, right to life, was relied upon in Unnikrishnan in 1993 to say, if you accept in theory that there has to be atmosphere where every individual should be allowed to reach the highest potential, which as a human being he can, then how do you expect youngsters of this country to attain that potential unless you give them free and compulsory education? And therefore the Supreme Court for the first time read into Article 21, right to life, or right of every child in the age group of 6 to 14 to have free and compulsory education at the expense of the state. If you ask me, this is the highest level of cases of judicial activism. There can't be anything greater than that. That you read into something a constitutional right and give that right to education to every child in this country, crores and crores of children, at the expense of the state. We have seen a number of decisions of the Supreme Court leading to various amendments. Say, for instance, Indira Sahni. Indira Sahni led to 3 amendments. Number 1, there can't be reservation in promotion. Indira Sahni said. There came an amendment. There can't be backlog vacancies reckoned for the purposes of a year when you arrive at 50% formula. Another amendment came. Indira Sahni also dealt with 10% EWS cannot be granted. Another amendment came. So what we have seen over a period of time, Inamdar said that in private professional colleges, unaided colleges, there can't be a reservation. Parliament came out with an amendment within 6 months. Now, these are the cases where what you will find that the determination by the court and the intent of the Parliament do not travel together. There has been some collision course at some level or the other. What emerges thereafter is what is our ethos. But at least for a time being, that there had been some kind of collision course between the court and the parliament. But when it comes to this Unnikrishnan law, parliament did not say that this is not a fundamental right. It took them 10 years. Mark you, 10 years. Why? Because they had to arrange the finances. Because it was a tall order, absolutely tall order, that every child in this country had to be educated. So that from 93 comes the determination by the court, 2002 comes the amendment, and what we get on the fundamental rights chapter is Article 21 capital A. Now it becomes the fundamental right of every citizen. And this is the march of what is called Article 21. There can't be anything, lesser or greater than this, that your reading of Article 21 leads to a constitutional amendment to say that very well we will give effect to your judgment. And in true sense of that, now you have every apparatus, and that's exactly what, ladies and gentlemen, is going to be the changing feature and face of this country. We have such a huge population, 140 lakh people. If we utilize this as a resource, as an educated force, this is why we see so many sort of CEOs in some of the American corporations, some of the developed countries where the educated youth from this country is actually gaining ground there. And 2002 was the date when this right to education became a fundamental right. We have traveled 22 years. 2 generations have passed out from school. 2 more generations and you will see the changing face of this country. And that is something, mind you, the roots are in Unnikrishnan. And that's what has been given as part of our guarantee by the courts. Not just by the constitution makers, as somebody said in the beginning, constitution is a very, very dynamic concept. It's not a static document. It's a document which has to be read in conjunction with the times, with the changing sort of, philosophy's changing nature. And that's exactly what we have been able to achieve. So out of 3 articles, 14, 19 and 21, enough for the purposes of this lecture, so far as 21 is concerned. Let's move on to 14. Well, 14 has 2 facets, every one of us knows. The negative part, no person shall be denied equality before law. That's the negative idea. And the positive idea follows thereafter. And shall be afforded equal protection of laws. We all know 15, 16, again, when I was actually walking through the museum here, and very beautifully put, Champakam Dorai Rajan was the first amendment responsible case, was from this court. Champakam Dorai Rajan, the determination by 5 judges, was actually responsible, among others, to have first amendment to the Constitution. So that was why? Because again, going on with what is called affirmative action process. And the speech of Jawaharlal Nehru while tabling that amendment actually tells us the story. What he said is, we always assumed that Article 14 in its pristine form, when it says negative and positive ideas, so under that umbrella of positive ideas, the state can always extend some protection to certain sections of the people. But if the court says you cannot, we will come out with a specific amendment, and therefore 15(4) was brought on the statute book. It has always been considered 15 and 16 are manifestations of what is called the second part of Article 14. That is to say, equal protection of laws. Do you know the affirmative action that this country has accepted over a period of time? The affirmative actions given by other countries do not come anywhere near this. You know, our Article 330 and 332 says that scheduled caste and scheduled tribe shall be given due representation in Lok Sabha and members of the state legislative assembly in proportion that their population has to the general population. So therefore 15%, 7.5%. Now in a house where the strength is 540, 15 would mean about 70, at least every house must have scheduled caste people. Do you know how many African Americans have up till now been senators in US after 250 years? Only 16. Look at that, all these 250 years there have been only 16 African American origin people, that's black Americans, only 16 of them, and what is affirmative action in my country? And that's the manifestation of Article 14 read with 15 and 16. And that's how we are widening this umbrella or the spectrum of this affirmative action. To begin with, we thought only of scheduled caste and scheduled tribe, and to a certain extent, Anglo-Indians, when 2 seats could be nominated for them. That Anglo-Indian now has vanished that as a beneficiary class. But what are the classes that we have added? We added first OBCs or SEBC through Mandal. Then we added number 2, women through 73rd and 74th Constitution Amendment, that in Panchayat and municipal councils 1/3 seat should be reserved for ladies. Then 5, we added children under 21A, that very well, you know, the children, regardless of community, every child between 6 to 14 must be given compulsory free education. Then number 6, EWS. Again, one more idea comes added. Then last, now the ladies should not have just the representation at village panchayat or municipal level, but even in the parliament and state assemblies. That's the kind of logic which actually flows from what is called your affirmative actions in terms of the positive aspect of Article 14. Now this is the dimensions that we are reaching as a country. This is not a static idea, this is an expanding field. An expanding field to such an extent that perhaps idea is that very well every section of the community should be kept together. And so therefore that fraternity as a principle should be the underlying idea through every governmental process. Very well, now the time is short, so I'll just jump to 19 now. 19 has always been a very, very bedrock of, you know, all these kind of litigations. Do you know what was the case number? There was a very interesting idea which was floated by a counsel coming from this court, who said Gopalan was original petition number 13 of 1950. Gopalan was decided in May 1950. January 1950, the Constitution came into force. So it became the Supreme Court for the first time. The history doesn't know which were those original petitions 1 to 12. The first recorded and recognized case is Gopalan, 13 of 1950. Which were those first 1 to 12? We don't know. But there is only one petition which is a reported judgment, and that is petition number 10. Both were decided on the same day, 19th of May 1950, and that case pertained to 191G. So that's where we see that that's how the ethos has always been developing. 19 has always been taken to be the charter of freedoms for the citizen. Look at the tussle right from Kameshwar Prasad Singh and the idea of 31A, B, C getting onto the statute book along with 9th schedule. What has been the tussle? The tussle has always been, on one side you have agrarian reforms where the entire assets are to be shared amongst the members of the public as a principle. And on one side you have right to property claimed by that person whose property is supposed to be divested. So it has always been a tussle to manage both these fronts on that scale. And that's how you will see all the amendments right up to Keshwanand Bharati had their genesis in what is called 19(1)(f) and 31 as a right. Well, we learned from our experiences, and 44th Amendment actually sort of, allowed 19(1)(f) to vanish from the statute book. Many people thought that 19(1)(f) having been obliterated, perhaps I think there would be catastrophic situation. But we have survived. We have survived with 300 capital A being a substitute to be good enough for all practical purposes. It hasn't, till this date, hasn't hampered any acquisition of property by any individual. And that's again is a beauty of this constitution. So therefore, that what shows is that this Indian democracy is so resilient that it can accept, adopt and absorb any shocks, including the shocks which we felt in 74 to 76. That is also something which this democracy accepted. How and where does the strength come from? The strength comes from, one, the constitutional apparatus which are going on so smoothly and doing so well. Number two, the freedoms which are granted to the citizens have been so wholesome that yes, it hasn't hampered the growth. In fact, it has sort of, pushed them to go further up and up. And that's what the development of this country, and we owe it to those founding fathers who had the foresight to give this beautiful document to us. Let's pay homage to them. Thank you so much.
Thank you, sir, for explaining the nuances of the Constitution, its origin, evolution, and its all-embracing nature in simple language. We are greatly benefited by this address. I am sure the students who are here in large numbers will get excellent grades in their constitutional law papers from this address. Now, Ms. Jayalakshmi, who gave this meeting an auspicious start, will be felicitated by Mrs. Gandhimati, Senior Advocate. Mr. Parthasarathi, Senior Advocate, co-convener of TNSAF, will now render the vote of thanks.
Good evening to all of you. Honorable Mr. Justice U. Lalit, former Chief Justice of India, Honorable Mr. Justice D. Krishna Kumar, Judge of the High Court of Madras, other honorable judges of the dais, retired and former judges of the Madras High Court, esteemed law officers, senior advocates and advocates, ladies and gentlemen, and dear students. It is both an honor and privilege to extend our deepest gratitude to everyone who has gathered here today to commemorate our Constitution's 75 years journey. We are indeed fortunate to hear from those whose lives have been dedicated to upholding the constitutional values that define our nation. Firstly, I extend my sincerest thanks to Justice U. Lalit. Sir, your insights today on the progression, resilience for constitutional guarantees have resonated deeply with each of us. Your words remind us of the power of the Constitution to do justice, to protect rights, and act as a shield against inequalities. Thank you for having so kindly come down to Chennai to address us today on this subject, and thank you for helping us all reflect on the principles that hold our country together. Lord, you will notice one thing. I was able to guess what you would be speaking, and I come with a prepared vote of thanks, and I have not missed out anything from your talk. Your contributions serve as a reminder that the Constitution remains at its core a living document, and that it must constantly evolve to meet the needs of the society. I also express our heartfelt gratitude to Honorable Justice D. Krishna Kumar for sharing your perspective on this occasion. Your reflections on the work done by the courts to uphold individual rights and social justice were inspiring. A special note of thanks to the Honorable Chief Justice and his companion judges of the Building Committee, Honorable Justice D. Krishna Kumar, Justice R. Subramanian, Justice R. Suresh Kumar, who readily came forward to give us this auditorium for the purpose of holding this function. A special note of thanks goes to our Secretary of the Forum, Mr. Om Prakash, Senior Advocate, and his team comprising of Senior Advocates Mrs. Hema Sampath, Srinath Sridevan, P.V. Balasubramanian, A.L. Gantimati, Dakshayani Reddy, V.P. Sengotuvel, Mani Shankar, Gautaman, and all the other senior advocates. I will be failing in my duty if I don't thank the young students who readily come forward to help us to put together this function. They are young volunteers. They have been, so I am not able to, due to paucity of time, I am not able to mention there are about 16 volunteers, young friends, who have helped us throughout, right from the beginning. And but for their assistance, it would not have been possible to put up such a grand show. And finally, I thank the Honorable Subordinate Judges and the Principal Judge City Civil Court and others for gracing this occasion, and the Registrar of High Court for providing us with all the facilities. Thank you one and all.
At the close of the meeting, all of you kindly join us for high tea at the ground floor. National anthem now.
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
As a mark of courtesy, kindly wait for the honorable judges and others to leave before we leave. Go to the ground floor for high tea.